Good afternoon. My name is Lisa Swinney, and along with Betsy Watson and Sarah Tinker, we are going to discuss some legal and ethical issues facing um, educators today. The first issue we will discuss is religion in public schools. The First Amendment says Congress shall make no law respecting an establishment or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, the right of the people to to people peacefully to assemble and to petition the government for a redress of grievance. The two clauses that we want to look at, the first one is the Establishment Clause, the separation of church and state, and this prohibits the state from passing laws that aid a religion or show preference for one religion over another. The next is the Free Exercise Clause. This prohibits the state from interfering with individual religious freedoms. Religion can be utilized in the classroom if it's for historical, literary, ethical, or philosophical purposes.
A few issues concerning religion regard prayer at school and school events. Any prayer on school grounds or at school functions must be led by students only. Administrators should develop legal defensible guideline that is supported by the Supreme Court addressing any student-initiated prayer at school events. The next issue is the use of school facilities for religious purposes. Equal access to facilities must be given to all religious groups by schools. Schools can allow religious groups to access their facilities, but they do not have to allow access for religious services. And teacher religious rights, they must be respected unless they violate the Establishment Clause of the First Amendment. Accommodations must be made by school officials regarding the teacher's observance of religious holidays, and teachers cannot be discriminated when seeking employment opportunities because of their religious views.
So when it comes to freedom of expression for students, they are entitled to the same rights detailed by the First Amendment as any other citizens. These rights, like freedom of speech, of the press, and to peacefully assemble, may be exercised by students as long as they do not cause substantial disruptions, cause damage to school property, or result in violence. There are a couple of cases provided in the text that address these issues. The Tinker case involves students wearing black armbands to school in protest of the government's policy in Vietnam and were consequently suspended, even though wearing these armbands did not cause disruptions in schoolwork or behavior. The school officials did not want these opinions being expressed specifically about the Vietnam War. Eventually, the U.S. Supreme Court found that it is unconstitutional to discipline students for wearing symbols that express opinions unless it can be proven that they largely interfere with the educational process. In the case Blackwell versus Issaquena County Board of Education, a principal banned wearing political buttons after students were found causing a disturbance in the hallway when they should have been in class. The students wearing the buttons forced them on other students and encouraged innocent students to walk out of school with them when they were suspended. The court sided with the Board of Education as it was clear that the violating students intended to disrupt school routine and interfere with other students' learning. Lastly, in the U.S. Supreme Court case involving Bethel High School, a student gave a speech during a school assembly that contained excessive sexual innuendos when describing another student. He was suspended from school and his name was removed from the list of student speakers allowed to talk at student assemblies. After several appeals, the U.S. Supreme Court ruled that a student's right to express unpopular opinions must be balanced against the school's intent in teaching appropriate behavior. These cases provide a couple of examples of how a school system must balance a student's right to express him or herself with maintaining a peaceful and safe school environment. There is an administrative guide for freedom of expression. Administrators may restrict freedom of expression if there is indecent or offensive speech, if there is destruction of school property, or vulgar or obscene material. The time, place, and manner of freedom of expression can be regulated by school officials, and school officials must have legitimate cause for prohibiting freedom of expression.
The next issue regards search and seizure of students. The 14th Amendment provides protection for students against unreasonable search and seizure. Reasonable searches are those that do not violate students' constitutional rights. They can be conducted if reasonable suspicion is obtained. This suspicion must be information that students or teachers received, which are viewed by the administration as reliable evidence. Any gut feelings or a hope of finding illegal substances are not justifiable reasons to authorize a search. Reliable information must be presented of violations that could jeopardize the safety of students. In the 1985 case, New Jersey versus TLO, the Supreme Court ruled that the searches in the school setting are subjected to the standards of the 14th Amendment, but school officials do not need a warrant to search students. Requiring a teacher to obtain a warrant before searching a child suspected of an infraction of school rules or of the criminal law would unduly interfere with the maintenance of the swift and informal disciplinary procedures needed in the schools. Any searches involving law enforcement must be followed by the precedence of a warrant. Before the search, parents must be notified, and the attempts should be documented to verify the effort. The next legal process is due process, which is the essential focus of fundamental fairness, including fair processes and fair procedures. The due process protects students against random or unpredictable searches and acts by school officials. The Fifth Amendment Due Process Clause provides protection to individuals against the government from unfairly depriving them of life, liberty, or property without due process. The 14th Amendment Clause allows individuals the opportunity to a fair legal proceeding and a right to be heard before the state and school officials can deny them of life, liberty, or property. These cases are balanced by the court to determine the appropriate procedures that need to be taken that are proportional to the threat of students' liberties. There are two aspects of due process. Both of these aspects must be met before any action can be taken against the students. The first is procedural due process, which deals with the steps that must be taken in order to address any alleged violations of an individual. The person being charged must be notified and given the opportunity to be heard at a proceeding. The next aspect is substantive due process, which deals with the issue at hand to determine if any reason for the charges exists. This ensures that school officials cannot randomly or erratically subject students for expressing their personal freedoms of speech, assembly, and religion. School officials can only act if the safety, health, or welfare of the faculty and students are at stake or jeopardized.
The next issue is liability and student records. The Family Education Rights and Privacy Act protects confidentiality of student records. The act, commonly referred to as the Buckley Amendment, was enacted by Congress in 1974. It guaranteed parents and students a certain degree of confidentiality and fairness with respect to student records. The law is designed to ensure that certain types of personal identifiable information not be released unless the parents consent. School personnel should not discuss students unless there is a specific need for discussion. When school personnel communicate personal and sensitive information to another unauthorized person that results in damage to students' reputation or that damages the respect which the student has held, they may face charges of libel or slander. Defamation involving school personnel. First, slander is oral defamation, which occurs when school personnel inadvertently communicate sensitive and damaging information contained in student files to others who have no need to be informed. Libel, unlike slander, is written defamation. Teachers, counselors, and principals should refrain from including damaging information in student records for which there is no basis. Good faith. This is qualified privilege is based on the premise that the educator is operating in good faith. When damaging or sensitive information is communicated to others who have no need to know, good faith has been violated. And then lastly, acts of malice exist when there's no intent to harm or injure. Intent is an important element regarding malicious behavior. When statements are communicated about a student, either written or oral, with the intent to injure his reputation, a tortious act has occurred, especially if these statements are false. Individuals with disabilities is the next issue. An individual with a disability is defined by the ADA as a person who has a physical or mental impairment that substantially limits one or more major life issue. Three aspects of that we'll be looking at is under the National Council on Disabilities. The first is teacher qualification. First, the special ed teacher must hold a bachelor's degree, and regular classroom teachers have the responsibility of identifying students who may need special services in order to receive the full benefit of an education. This function must be executed before any formal assessments or special programming occurs. Each student with individualized education program or an IEP must meet the following requirements. A statement detailing the child's present level of education performances, a statement of annual goals, a description of specific educational services, a description of transitional services, a description of services as well as a timetable, and an explanation of relevant criteria. Education-related services requirement one is the least restrictive environment, and this states that children with disabilities must be placed, when appropriate, in an educational setting that offers the least amount of restrictions. This view is supported by the philosophy that children with disabilities should be educated under normal classroom conditions with children who are not disabled. The following statutes were enacted to protect individuals with disabilities from discrimination and to provide them with legal access to education opportunities. The first is the Individuals with Disabilities Act. It guarantees children with disability ages 5 to 21 the right to a free and appropriate education. In 2004, amendments were made with significant changes to the Act. This also establishes substantive and procedural due process rights of children with disabilities. The next is the Americans with Disabilities Act of 1990. And this gives rights and protections to individuals with disabilities that are much like the ones provided to individuals based on race, sex, national origin, and religion. The ADA amendments of 2008 revises and encompasses the impairments that substantially limit a major life activity. They also amended language that states that mitigating measures, including assistive devices, auxiliary aids, accommodations, and medical therapies and supplies have no bearing in determining whether a disability qualifies them under the law. And last is the Rehabilitation Act of 1973, or Section 504. And this says schools must guarantee that programs, services, and activities are accessible and responsive to the needs of individuals with disabilities when the district's programs and activities are considered in their entirety. And a student qualifies for 504 services based on the assessment of a support team. Based on the student's disability, he must not be limited in ability to access the regular education program or may not require specialized services. Appropriate interventions must be noted in the IEP, which the IEP team consists of the student's parent, the teachers, and a administration someone from the administration.
The Alabama Educators Code of Ethics states that it is the primary goal of all educators to provide an environment in which all students can learn. The Code of Ethics covers 9 different categories of conduct. These categories are professional conduct, trustworthiness, unlawful acts, alcohol, drug, and tobacco use, public funds and property, remunerative conduct, maintenance of confidentiality, and abandonment of contract. I'm only going to describe 4 of these that seem most important. Standard number 1, professional conduct, refers to school staff encouraging and supporting colleagues in upholding high standards and prohibits behavior such as harassment, misuse of test materials, inappropriate language, physical altercations, and failure to supervise students appropriately. Standard number 2, trustworthiness, refers to accurately relaying facts about educational matters and advocating for equitable opportunities for all children. Unethical behavior under this standard includes but is not limited to falsifying employment history or criminal records when applying for jobs, falsifying student records, or student evaluations. Standard 4, teacher-student relationships, describes teachers fulfilling roles of mentor and advocate for students and providing environments that keep students safe and supported. Unethical behavior in this category would include, but is not limited to, child abuse of any kind, cruelty towards children of any kind, any unlawful sexual act, harassing students, and providing any kind of drug or alcohol substances to students. Standard 8, maintenance of confidentiality, directly states that an educator should comply with state and federal laws relating to the confidentiality of student and personal records. Teachers are not to share confidential information such as disciplinary records, health and medical information, family income, or assessment results. Teachers are also not to violate confidentiality agreements related to standardized testing or any other agreements required by local or state policy. The Alabama Educators Code of Ethics goes on to describe reporting methods for breaches in the Code of Conduct and the responsibility that teachers have to report unethical behavior. The state superintendent has the authority to revoke certification, refuse to issue certification, or suspend an individual certificate as a consequence of breaches in the Code of Conduct.